Hilchos Ishus Perek Shnayim ve'esrim. The Laws of Marriage, chapter 22. We are continuing the list of rights that the husband has from his wife. Spent a bunch of chapters on the obligations of a husband to a wife. Yesterday we started the rights that a husband gets from his wife. Yesterday primarily we talked about the fact that the husband has the rights to his wife's handiwork, whatever she produces, whatever she finds, the work she has to do for him. Today we're going to discuss two more of those rights. Number one, the right to inheritance. The fact that when a wife dies, all the property goes to the husband. That's going to be relatively short, just the first couple of halachot. The majority, the body of this chapter talks about the right that a husband has to make use of his wife's property. Any property she brings into the marriage, we've seen already a number of times, there's two categories. Nichsei tzon barzel, the iron sheep property, which the husband accepts at a fixed value, and then any losses or profits accrue to him. Or nichsei milog, usufruct property, which means you just use the fruit. The proceeds go to the husband, but the actual land remains in the possession of the wife. And that's going to lead to a whole discussion of which properties a woman can sell or gift during the marriage, which properties the husband can gift or sell during a marriage, all within the context of the rights that he has to his wife's property. So we begin with inheritance, the laws of Yerusha. It says the Rambam, halacha aleph, habal, koidem, l'chol adam, b'yerushas ishtay. A husband has first preference, first rights over any person when it comes to inheriting his wife's estate. So when does this right begin? When is that moment when we say, now if she dies, it belongs to the husband? The halachic definition is, as soon as she leaves the possession, the jurisdiction of her father. Even if she hasn't yet entered the chuppah. Remember, in halachic marriage, there's first you give the ring, that's called erusin, betrothal. She's already your wife to the exclusion of all others, but then you actually take her into seclusion to a chuppah, that's nisuin. Even before nisuin, so long as she left the jurisdiction of her father, the Rambam will soon describe what that looks like. Since she went into the jurisdiction of her husband, he now inherits her. Now, in order to appreciate the following halacha, take a look at the screen here. And you can see, we're just going to, for illustrative purposes, this is the father's house, where the woman is coming from. This is the husband's house, where the woman is going to. In the next halacha, it's going to be kind of variations between all of these people. We have the woman and the husband. These are the two primary characters of our halacha. Then we have the father, who still has jurisdiction over his daughter till she leaves his home. And then we have what's called the father's agents, or the husband's agents, because sometimes the husband himself doesn't want to make the betrothal, he'll send his agents to pick her up. Or the father won't want to send his daughter off alone, he'll send agents with her. And we're going to see that sometimes just the fact that there are agents there can still consider her to be in the father's possession, or can already consider her to be in the husband's possession, depending on which agents they are. So these are the five characters, let's keep them in mind. It says the Rambam, Ketzad, what does it look like practically, leaving the father's jurisdiction, entering the husband's? Ha'isha shenis arsa. A woman is already betrothed, the husband already gave her a ring. Umasra aviha lebaila, oy lishluche baila. And here, the father has already given her either to the husband directly, or to the husband's agents. So him and his agents are still by his house, he's staying home. But he's handed off the woman either to the husband, or to the husband's agents. Oy, or another scenario, masruha shluche ha'av lebaila oy lishluchav. Or the agents of the father gave her over to the husband or to his agents. So it wasn't the father directly handing off the woman, it was the agents handing off the woman. The point is, she's already been handed off. And she dies on the road. While they're traveling to the home, before he takes her into the home, because that's real chuppah. Chuppah, according to the Rambam, is taking her into seclusion. Before they get home, she dies on the road. Even if the document, the marriage document, is still back home in her father's house, at this point, the husband already inherits her because she's left the jurisdiction of the father. She's in his possession, even if he hasn't taken her home yet. Next scenario, v'chein. Similarly, im holach ha'av, oy shluchei ha'av, im habal. The father, or the agents of the father, and I put them just both together, all here, are walking with the husband. So here they're all together. In a way, he's still holding on to his daughter. The wife is still in the father's jurisdiction. However, on the way, this picture is not so accurate, but on the way, v'nichnas ima baila baderech lechatzer. On the road, the husband takes the woman into a specific courtyard, not to his house, into a courtyard on the way, v'nisyachid imasham l'shem nisuin, and secludes himself there with her for the express intent of marriage, v'meisa, and then she dies before getting to the actual home. Again, at this point, the husband inherits her. Here it's a bigger novelty because here the father's still with them. But he's taken her into a home with the express intent of marriage. Even if it isn't his home, she's already his. But if the father stays with the husband to take her to his home, those fathers, helicopter parents, holding on to the daughter. I'm not letting go till I see you take her into the house. Prove to me that you have a house. So he's with her, literally with her. Bring her to the husband's home. Or the father's agents. The father is happy to stay home, but he himself tells the agents, don't let her go. Stay with her. And they're always with the husband. Even if the husband goes into a courtyard to go to sleep, but not with the express intent of marriage. As regular passerby, regular travelers will go into a hotel to stay the night. Since the father or the agents are still with her, and he hasn't yet secluded himself with her with the express intent of marriage, in Mesa, at this point, if she dies, the father retains the right to inherit her estate, even if her marriage document already is in the husband's home. But again, he's still holding on to her. He hasn't let go, so she doesn't have any rights. Gimel, let's say halachically, she was already out of the jurisdiction of the father. She's already past majority, or she's an orphan, or she's a widow. So she's taking her own walk. Husband says, come meet me at my house at this time. She leaves her father's house officially to enter into the marriage with him. But nobody's with her. Not the husband, not the agents. And she dies on the road. Counterintuitively here, husband doesn't inherit her. Because even though the condition was she has to leave her father's jurisdiction, and she already has, by dint of her age or her marital status, but now that works to her advantage. Because she's operating in this marriage on her own, she's fully on her own. Until she enters the husband's estate, he doesn't get to inherit her. Halacha Dalet. Interesting question. Hanay say Isha shi asura. If you married a woman that you shouldn't have married, she's forbidden to you. Do you inherit her if she dies?
No. Why not?
So there's an interesting distinction. If you remember way back in the beginning of these halachot, we saw two categories.
You're talking about Kohen and Busha, things like that.
Mm-hmm. Kohen marries a divorcee. Does he inherit his wife? It's a good question. So the Rambam says, Hoyel v'yesh lo ba kiddushin, since the betrothal takes hold, in mesa tachtav yirashena. If she dies under him, then he will inherit her. Which implies, remember the other woman, there was two categories of women. There's erva. Erva is a woman forbidden to you on penalty of excision, like the highest level of prohibition. Those, when you give a ring to them, it doesn't even take hold. So the Rambam implies that in those marriages you wouldn't inherit her. But let's say a Kohen who marries a divorcee, it's only a lav, it's only a regular penalty of prohibition. Since the kiddushin takes hold, he can inherit her.
Huh? Perform kiddushin in this case. You go to a rabbi.
Oh no, the rabbi won't do it. This is a guy who does it himself. He goes over, he gives her a ring, he says, two witnesses, the whole business. Yeah. Similarly, if somebody marries a minor, even though the kiddushin are incomplete till she gets to the age of majority, if she dies under his jurisdiction in this age, he inherits her. Remember these terms? Cheresh is a deaf mute, pikech is a normal, competent person. So if a competent person marries a deaf mute woman, if she dies, he doesn't inherit her. Because the marriage to begin with is weak, and he entered the marriage knowingly that she's a deaf mute, doesn't get to inherit her. On the other hand, if a deaf mute marries a competent person and she dies, he does inherit her. Because she has competence. She's mature. So we say, with consent, she got married, and she handed over her money to him in case of death. Even though he's deaf mute, he'll take over the estate. Halacha hey. A young girl enters a kiddushin with the consent of her father, as is allowed. But but she then consummates the marriage without her father's consent. Bein befanav, bein shalei befanav, whether in his presence, in other words, he's in town.
But if you need Kadsha,
Typically, when
the date of the year.
yeah, this is we saw in chapter 3. Typically, when a father marries off his daughter, he has to be present for both stages. First the kiddushin, or at least agree. Kiddushin and nisuin. Now, what if she goes? Kiddushin happens with his consent, nisuin doesn't. So, whether it didn't happen with his consent, bein befanav, bein shalei befanav, whether because he's in town or he's not even in town. Either way, it wasn't done in his consent. The father can retroactively protest and undo the marriage, as we've explained in chapter 3. But even if the father was quiet, he didn't say this way or that way, in Mesa, if at this point this young girl dies, ein habal yersha, the husband does not inherit her, unless the father expressly desires the marriage. So in terms of the marriage taking effect, if he's quiet, the marriage takes effect. He hasn't protested. But that quietness, that silence, isn't powerful enough to transfer now the estate of hers to the husband, unless he expressly says, yes, I want this marriage. And the Rambam concludes the discussion on inheritance by saying the following. Hoidu ha'ga'onim. The Ga'onim have given out a ruling. Doesn't say in the Talmud, but they came up with this. Sheha'isha shechalsa. A woman is sick. She sees she's going to die. Ubiksha mi ba'ila sheyagarshena v'teitze b'lei ksuba. And she asks her husband, divorce me. I don't even care. Don't even give me a ketubah. Just divorce me, kedei shelo yirashena, just to protect her estate. She doesn't want him to inherit her. So she says, listen, divorce me. I'll relinquish my rights to the ketubah. Just don't inherit me. Ein shaymila. We don't listen to her. That's basically it's an unfair request. The afilu amra, even if she says, I hate him. I don't want to be with him. But since the circumstances kind of show that it's really she's doing it out of her sickness and to protect herself, ein shaymila. We don't listen to her. Yet we don't treat her like a rebellious woman. Remember that woman who wants to withhold relations? She's a rebellious woman. We take away her ketubah, the whole thing. So we don't go this way or that way. We don't listen to her request. We don't treat her badly. V'din yafeh huzeh, says the Rambam. This is a very nice way to judge the case, and the inheritance remains in the husband's estate. That concludes the discussion on the husband's right to inheritance. Now we move on to the next right, the husband's right to use property that his wife brings into the marriage. Says the Rambam Halacha Zayin, Kol nechasim sheyesh leisha, all property that a woman has, bein nichsei tzein barzal, bein nichsei maloig, whether they are guaranteed property or usufruct property. Remember, these are the big terms coming up over here. The reason why it's called iron sheep is because shepherds had this custom. You would give them your sheep to watch at a fixed value. Even if they lost the sheep, they would have to repay you that fixed value. So it was an iron sheep. Milog, the word milog means balding, plucking. Because the idea is the woman owns the field like a head of hair. You pluck out the hair, but the head remains. So the husband plucks out the fruit, but the land remains. So whether they're tzoyin barza, whether they're miloig, habal oichel kol pirsein b'chayeha. The husband gets to eat the fruit. If these fields grow stuff, or if the houses bring in rent, he gets to have everything in her lifetime. V'imesa b'chaye baila, if she dies in the husband's lifetime, yoresh baila hakol. The husband inherits everything. Lefichach, therefore, if a woman sells usufruct property, again, the real estate is hers. She has the right to the land, but she sells the land after the marriage. Even if she owned these properties, even before she got betrothed, since she brought them into the marriage, and the husband understood that he has the rights to the fruit, all the days of her life, so long as she's alive, the husband can go over to those purchasers and keep on picking the fruit off of that field. Because the purchasers knew she's in a marriage. If they buy it on that understanding that the husband will take the fruit. Avolei gufa karka. He's not entitled to the actual land because it's her property. He doesn't get any rights to those properties until she dies. Mesa b'chayav, if she dies in his lifetime, moitzi haguf miyada lekuches b'lei damim. Husband goes to the purchasers and he literally expropriates the land. Commentators explain the buyers knew about it. If you bought nichse milog from a woman, you were taking a risk. True, if the husband dies, the property will stay yours, but if she dies, it goes back to the husband. Without even any money. No need to pay for it. Except if the cash that they actually used is still in your possession, if the cash that the buyers used to buy the property from the woman is still there, the husband should give them back. It's only fair. The cash is still here. Give him back the cash. He cannot say, oh, maybe it's a lost object that she found and it's mine. No. If it appears to be the buyer's money, give back to the buyers. But Medvarim Amurim says the Rambam, when do we say this, that the woman has no rights to sell the property? Or that if she does, the husband can keep on getting the fruit. If it's property that the husband was aware of. He knew the wife owned these properties. But if during the marriage, or even before, the woman got some property in a different country, which the husband wasn't aware of, happens all the time today, I own this, I own that, I didn't tell you, you didn't know, and she sells them, michra kayam. The sale is valid. Because the whole idea is that a husband goes into a marriage on the assumption that he's going to use the fruit of the property that he knows. But if he doesn't know the property, so he didn't go in thinking about them. So she can sell them. Also a betrothed woman who sells property before the actual marriage, michra kayam, her sale is valid. Husband has no rights, zero rights, to his wife's property until he actually consummates the marriage. It says that a woman during a marriage writes all her property away to somebody else. A close person, a far person, relative or not. Sorry, so yeah, I misspoke. Before she gets married. But she puts in a very interesting provision in which you can tell that she's trying to protect herself. Even if it says clearly that in case of divorce or in case of widowhood, the gift goes back to me. So you can tell she's only giving it away for the husband not to have any rights over it. She says, listen, I'm giving it to you. If the marriage ever dissolves, it's coming back to me. As will be explained in the laws of Matana, in the 12th book of the Rambam. Too bad. She made a good condition. Husband has no rights. He gets no fruits. If she dies in his lifetime, he doesn't inherit them. Because she gave away the gift before she gets married. And indeed, if she dies in the lifetime of her husband, the guy will get it fully. Because the only provision was if I get divorced or my husband dies, I'll get it back. But if I die, if the woman dies, it actually is a full-on gift. So in a way, she gave it to that guy, and that's it. Husband has no rights. Not only that. Even if she gave away part of her property, or all of them, before her marriage. And she said, you have rights to this property today, starting today, but it only goes into effect when I actually want it. In which case, he never gets a full acquisition until she actually desires it, which could be deep into her marriage. Still, the husband cannot eat from the fruit of that gift because it began before the marriage, even if it only goes into effect later.
In writing with two witnesses.
Yeah, it has to be clear. If she dies in this case, he again doesn't inherit her. Halacha Yud Shemeres Yavam, a woman waiting for Yibum. Okay, this is going to be a really classic case. It's going to come up again and again as we go into the actual laws of Yibum. It's fascinatingly, the source of Yibum is in today's Chumash. Today's portion of the Parsha, the fourth Aliyah of Vayeshev, is the first time we see about Yibum. A brother marrying his dead brother's wife. Yehuda gave his daughter to Tamar, heir. They married, his son married Tamar. Heir passed away. He gave her to Onan because of Yibum. So, it's fascinating we're learning about this today. Yibum means you have a guy, can't really see him now because he's dead. He married this woman. They didn't have any children. Okay? Then he dies. This brother, this is the brother of a dead guy, he has to marry her. Now, when this guy died, he left some property. I should say, let's call this property that's hers, okay? Basically from this original marriage. So the Rambam says, Shemeres Yavam, a woman waiting for Yibum. Yesh la limkar v'litin b'matana nechasim shenaflu la kishish shemeres Yavam. Any property which came to her while she was in this state, she can sell, she can gift. Ve'en la Yavam peiros. The Yavam, that's this guy, the guy who was about to perform Yibum, gets no rights to the fruit. Afilu b'nichsei tzayin barzel she'ichnisa la'achid. Even in the guaranteed property which she brought into the original marriage, in which case the husband took the rights. So it's seemingly his brother's and it should transfer to him. he gets nothing ad sheyichnes till he actually consummates the marriage, because yibum only goes into effect when the marriage begins. Mesa kishehi shemeres yavam, so much so that if she dies while she's waiting for yibum and the husband never actually consummated the levirate marriage, yersheha me'aviha yershin b'nichsim aloig shala, her father's heirs. In other words, it stays in her family. All the nichsim alag, all the usufruct properties go to her father's heirs. V'chatzi nichsei tzayin barzel, plus half of the guaranteed property. The yershei habal, and the heirs of her original husband, yershim ksubasa v'chatzi nichsei tzayin barzel, get the rights to the ketubah, which remains unpaid because she's dead, and also half of the guaranteed property. The yershei habal chayavin b'kfurasa, the heirs of the husband are obligated to bury her, but this new guy, he gets nothing because she died. The whole first marriage is dissolved. Shemeres Yavam, says the Rambam, another law about this woman waiting in the wings for Yibum, Ksubasal Kol Nichse Baila. The lien that her ketubah has is on the entire property, on the entire estate of her husband. Lefichach, therefore, Ein HaYavam Yachal Limkar B'Nichse Achiv, this guy, Yavam, even though halachically he inherits his brother's entire estate, he can make no sales. Ben kaidem yibum ben achar yibum, whether before or after the levirate marriage is consummated. V'imachar nasan matana oichalakim echav benichse ames ben kaidem yibum ben achar yibum le'asa klum. If he sells, if he gifts, if he divides the estate with his other brothers, before or after the yibum, he has done nothing. Shekvar nischayvu nechasim elo la'almana ligbes mi'an ksubasa, because the entirety of the estate is on lien to the widow for her ketubah to be collected, and therefore he can make no such sales. Kana says Yevimta, he says the Rambam, if he indeed marries the woman, he does the yibum, he brings her in, and his dead brother had left some fruit attached to the ground. In other words, let's say it's an apple orchard, and the apples were fully grown, ready to be picked, attached to the ground. Yimachru. These fruit should be sold. You buy real estate with the fruit, and the new husband can eat from those properties. But the fruit left on the original brother's property doesn't belong to him, in the sense that he cannot eat from it. Yud Gimel hiniach perish tlushin min hakarka. If the dead brother left produce already detached from the ground, a full pile of wheat, a full storehouse of apples, they were already picked. Or if he left cash or movable property, hakol shel yavam, all belongs to the yavam, to the new husband. Umishtamesh ben kamei sheyirtze, he can use them as he wishes. And she cannot stop him. Why? When it came to land, we said all the land is on lien to her ketubah. Movable property, as we've seen before, the sages enacted that a woman can also collect her ketubah from movable property. So why isn't the movable property on lien to her? It says the Rambam, it was only the Gaonim who made the enactment that a woman should be able to collect the ketubah from movable property. That rabbinic enactment isn't powerful enough to withhold the rights of this yavam from his brother's property, and to forbid him with this responsibility to not allow him to do business or sales or transactions with them. So we'll go so far as to put the real estate on lien, but not movable property. It absolutely does. It absolutely does.
And why wouldn't it apply now?
Because the marriage is transferring. This is how it seems. Since the marriage is transferring, so we can transfer some of the husband's rights, but not all of them, in the sense that he can make no business with them. You can do business with movable property. By the way, if he wrote it into the ketubah, like we do today, if the original brother had written in the ketubah, my wife has the rights to collect from movable property, then it's actually on lien, because then you put it in the document. But here we're talking about where it's not in the document. Yudalad, Yivama Shalihaisala Ksuba. A woman is in this state, Yivama, and for whatever reason, she's not granted a ketubah. And this is going to come up in different cases, laws like this, why a woman would not have a ketubah. For example, the classic example would be if the husband died after kiddushin before nisuin, the original husband. If a husband dies after betrothing his wife before consummating the marriage, he doesn't owe her a ketubah yet. But yet, she's still bound to the yavam for yibum. So if she's in that state where she doesn't get the ketubah, or she forfeited the rights, she pardoned the rights of the ketubah to her original husband, in this case, since there is no lien, the brother gets all the rights to the real estate of his dead brother, and he can sell and give as he wishes. When he actually marries this woman, this yivama, let him write to her a ketubah on her own for 100 zuz. She isn't a virgin, so only 100 coins. And at that point, all of his property will enter a lien onto her ketubah, like any other woman who gets a ketubah right, but only at that point. Before that, because she didn't have a ketubah from the first marriage, there's no lien, and he gets all the rights to the husband's real estate. Tesvav. Let's return, leaving the Yavama, back to these two properties. A woman, she brings into a marriage guaranteed property, which means the husband has all the rights. And then she sells it or gifts it. Bein lebayla, bein la'achirim, whether to her husband or to others, loy asas klum, her sale counts for nothing. Because nichsei tzon barzel belong to the husband. V'chein baal shemachar karka b'nichsei ishtoi, similarly if the husband sells land that belongs to his wife, bein nichsei tzon barzel, bein nichsei maleg, whether it's guaranteed property or user-fuck property, doesn't matter, loy asas klum, he hasn't done anything because it's her property. Tezayin machar mitaltalin shel nichsei tzon barzel. What if he sold not real estate, but movable property? The woman brought in a Lamborghini to the marriage. She says, this is yours, you take care of it, promise me a fixed value at the end of if the marriage dissolves, whether it goes up in price or down in price, it's all yours. And then he sells it. Even though he cannot, technically because it's hers, property is hers. If he did sell it, mimkar. The sale is a valid sale. If together, both the husband and the wife made a sale of user-fucked property, whether the buyer went to the husband first, then to the wife, or to the wife, then to the husband, bottom line is, since he bought from both of them, the sale is valid, because if they both agree, the husband has the rights to the fruit, the wife has the right to the land, and together they've sold off both of the property. A woman takes the user-fucked properties and she gifts them or sells them back to her husband. She says, now you have only the rights to the fruit. Here, have all the rights to the property as well. The sale and the gift, it's all valid. She cannot say over here, I only did that to give my husband pleasure, because he's already getting the fruit. So what have you done? You've actually relinquished the rights to the land. Any other property, guaranteed property, she can say that I didn't mean for the sale to be valid, I just meant to make my husband feel good. Keita, what does that look like? A woman sells or gifts to her husband a guaranteed property, whether land or movable property, or a field that he had clearly designated for her in the ketubah, or a field that he made record of in the ketubah, or a field which the husband brought in as a present to her, part of her dowry. If she sells it back to the husband, he has not acquired it. Even if they make a kinyan with her and she wants it, she can always retract. Because she only gave it or sold it out of peace in the home. I want to look good. I want him to feel good. Therefore, a husband has no way of proving that he owns any part of his wife's property unless it's user-fucked property, as we've explained. Because as long as it's guaranteed property, she can always say, nah, I sold it, but I only sold it to make you feel good. Nachat ruach. And therefore you don't get to keep it. You test. What if a woman brings in guaranteed property and they get lost or stolen? Movable property, lost or stolen. Now that they're gone, the woman forfeits the rights to the husband. She says, you know what, you can actually keep it. The kono mimeno be'edim, and we made a kinyan with witnesses. Here the Rambam says a novel rule. It seems to me, she can no longer say, I'm just doing to please my husband. Why? Because the properties are lost. They aren't here. If they're here and she sees them, she could say, you know what, I just did it for his pleasure. But if they're lost or stolen, what is that similar to? It's like making a kinyan with a woman that she has no responsibility over the property anymore. In that way, she transfers the status of this property to user-fucked property. Because in this case, the husband isn't bringing a proof to take anything away from her or to hold possession of property. All he wants to do is exempt himself from her demand that he pay. And so therefore, By handing over the responsibility, she relinquishes it totally. But if she had given a gift of movable property, iron sheet property, guaranteed property, but they're still extant, they're still here, you can see them, the husband has never acquired them, because all she can say is, I did it for my husband's pleasure, I didn't actually mean the sale to go through. A husband, interesting thing, he sells the wife's real estate, but not for an actual ownership. He sells karka lepeirot. He tells the buyer, look, you're going to have now the rights for the fruits. My wife still owns the land, but instead of me having the benefits of fruits, you get to have the benefits of fruits. Lo yasa klum. That's not a right. You have no right to do that. It's your right not to sell. The only reason the sages gave you the rights to the fruit from your wife's property is so you'll have more access to more funds to make more money for the home. But if you're selling it off, that's not fair. Therefore, if you sold it off as an investment, if you sold the rights of your fruit to somebody else, and you use the cash to make investments, then you listen to him, because then the purpose is being fulfilled. You're making money with it. A woman has actual financial resources. If she brings in the cash as guaranteed property, the husband can do business with them, commercial business. If she brings them in as usufruct properties, which means she only says you can have any proceeds, whether she brought them into the marriage, or they came to her as an inheritance, or someone gave them her as a gift, or movable property came to her as an inheritance, not actual cash, or was given to her. In all of these cases, what we do is we want to transfer them into usable property for the husband. So you use those cash or those mitaltalin to sell them. Buy real estate, from which you can eat the fruit. This way you turn it into nichse milog, and the husband benefits from them. Also a woman who was damaged. A whole section is in the 11th book of the Rambam. If someone hurts you on your body, they have to pay you a whole bunch of payments. Nezek, tsar, ripui, shevet, boshet, the damage, the pain, medical bills, unemployment, and embarrassment. So if somebody damages the wife, kol hamois, haru'uyes lasis la, yilakach ben karka.
Even if it's bishgaga or exit, from an exit.
Yeah. Yeah. Embarrassment you only pay if it's on purpose. You have to intend to embarrass the guy, but everything else you got to pay. Any money which is due to the woman belongs to the husband in that way. And so what you do with it is you buy land, and the husband will eat the fruit as regular usufruct property, as will be explained in the 11th book of the Rambam, in the laws of damaging somebody's body. Says the Rambam, if slaves come to her as an inheritance, okay, let's say she's married and then her father dies, leaving her a bunch of slaves. Even if they're old and seemingly useless, you cannot sell them because it keeps the honor of her father's household. If the husband leaves her olive orchards or vineyards, however, she got no right to the land. People will do this. They would own a field, but whatever grows, they would sell off to you. So let's say her father owned all the olive trees or all the vines, but not the land. If the vines or the olive trees produce enough to make up for their upkeep, so they're still productive, don't sell them, keep the father's honor alive. But if they're so bad that they're not making enough fruit to keep them going, sell the vines, sell the trees, use them for wood, and the proceeds you buy new real estate from which the husband will eat the fruits. If the wife gets an inheritance of fruit attached to the ground, they immediately belong to the husband. If they're detached, they belong to her. Sell them, buy new real estate, and eat the fruit of that new real estate. But if a husband divorces his wife, and there was fruit attached to the ground at the moment of divorce, unlike inheritance, it stays by her. They belong to her. If they were already detached, The husband already took his rights, they belong to him. A woman brings in a slave or an animal to the marriage as usufruct property. She retains the rights, husband can use the proceeds. The husband must provide for their support and all their other needs. They work for him. The slaves work for him, the animal threshes, plows for him, and he eats all the proceeds. Therefore, if a maidservant who was brought in as nichse maloig has a kid, labal, it belongs to the husband. Vlad behemas maloig, labal, if the animal has a baby, it also goes to the husband, because that's part of the fruit of this property. V'im gersha, if he divorces the wife in the end, the marriage dissolves. And the woman wants to pay the husband to get back that baby of the maidservant, to keep her father's honor alive through the slaves and their kids. Sheimin la, we listen to her. She puts that offer, and he takes the money, and she takes the slave. Chavav, a woman brings in 2 utensils, 2 watches, or 2 slaves, as tzoyin barzels, guaranteed property. Their total value was 1,000 coins. During the marriage, they get more expensive. Now they're 2,000 zuz. The gersha, and he divorces her. Since it's tzon barzel, guaranteed property means she only gets the fixed value at the marriage time, which is 1,000. Now each individual vessel is worth 1,000. So what does she do? She takes 1 for the 1,000 for compensation. And the second one, again, if she wants to put a cash offer and buy them to keep her father's honor alive, Shemila will listen to her. But by default, she only gets 1, because any profits accrue to the husband when it's tzayin barzel. If a husband gives a gift to his wife, whether it's land or cash, and she buys new land, here he can't say, it's now it's my property again, I get the fruits. No, you gave her the gift. If you gave her the gift, now it's exclusively hers. If another guy gives a gift to this woman, he says, listen, I'm giving it to you, I don't want your husband to have the rights to it. The husband gets to use it for whatever, so the wife gets to use it for whatever she wants. Then indeed, the husband eats no fruits of this because it's only hers. Similarly, if the woman sells the rights to her ketubah, on the benefit, because it's a risk, right? She tells the buyer, if the marriage ends because the husband dies or I get divorced, you get the money. If the wife dies, it's your loss and it goes back to the husband. That's called tovat hana'ah. It's a possible benefit. Whatever cash she makes from that sale belongs to her. And the husband cannot eat the fruit because, again, that's clearly for her. A woman brings in an animal to the marriage. There's a baby, which belongs to the husband, and it got stolen. You find the thief, he has to pay double. It's going to be, again, in the 11th book of the Rambam, we're going to see that if a person steals in secret and he's discovered, you have to pay kefil, pay back double. Who does double money go to? It goes to the wife. Because the double payment isn't the fruit. Even if the baby belongs to the husband because it's the fruit of the animal, but the double payment, that's not part of the fruits. If a man himself hurts bodily, damages his husband, his wife, all the money paid for the pain and for the damage and for the embarrassment belongs to her. Exclusively hers. The husband has no rights to the fruit, as will be explained in the laws of damaging. Now the Rambam doesn't mention unemployment wages and medical bills. Medical bills because he's always responsible for that, even if he didn't damage her. That's one of the obligations of the husband to the wife. And unemployment always goes to him because whatever money she makes from employment goes to him anyways. So no need to mention that. Only the damage, the pain, and the embarrassment goes to her. If somebody sells real estate to his wife, if the cash she used to make the purchase was already known to the husband, he was already aware of them, kansa, it's a valid sale, the husband retains the rights to eat fruit from that land. But if they were hidden money, He offered to sell her some part of his real estate, and she takes out 100K from her bank account. He didn't know where she got it from. Loy kansa. The sale actually doesn't go through. Shahabal loimer, because the husband can say, that's what I was looking for. Loy macharti ela kedei lehares hamoyes hatamna. The only reason I sold it is so she takes out her money from her secret bank account, and I know where her rainy day fund is, and now it's out in the open. But oislan hamoyes shaniru, and that 100K, which came to the fore now, you must buy real estate, becomes the husband's, and he can eat the fruit. One day, you wake up, you find in the wife's possession some cash, a movable property, and it's his word against hers. She says, somebody gave me a gift, it's my money. For who Aimer? No.
She doesn't have to reveal who gave her the gift?
No, it's not the gift, it's a gift. And he says, that's not true.
Very strange.
Yeah. It's your handiwork. You owe me the money. She is believed. However, he can declare a ban of excommunication in case his wife is lying. But since she says it's a gift, you buy real estate, and he eats the fruit. If she says, not only is it my money, not only is it a gift, but somebody gave me this cash as a gift on condition that you have no right. It's all mine. At this point, she has to bring a proof. That she has to prove. Whatever cash is in the hands of a woman by default is presumed to belong to the husband, at least in regards to fruit. Until she can bring a proof. She brings a proof, then she can keep the money fully. If she tells him, not I got a gift from somebody else. She says, you gave me a gift. You gave me the money that it should be a gift for me. What is hesed? Hesed is a rabbinic oath.
Okay.
It's the code name for rabbinic oath. She makes a rabbinic oath that the husband gave it to her, and now it's hers. He cannot eat any fruit from it. That's it. Lamed Beis. For these reasons, because we say that whatever money or movable property is in the hands of a woman typically belongs to her husband, you, as a regular guy, cannot accept a deposit from a woman, from a slave, or from a minor, because we assume it doesn't belong to them. If you did, so if you took it from a woman, give it back to the wife, give back to the woman. Mesa, if she dies, give back to her husband, because it probably came from him. You took it from a slave, give it back to the slave. If he died, give it to his master. Again, it's probably his. And if you took a deposit from a child, buy him either a Torah scroll or something which will have proceeds and he can benefit from it. In any of the cases, if these people, the wife, the slave, the minor, is about to die, and they say, this deposit belongs to so-and-so, so in other words, they name the rightful owner. If the guy who has the deposit believes them, he trusts this woman, he trusts the slave, he trusts the kid, do as they said. And if not, again, you give it back to their husband, master, whoever would inherit them. Because if you don't trust them, then you have to rely on the default law, which is it belongs to their relatives. Lamed Gimel. A woman has money that is supposed to go to the husband to buy real estate to get fruit. The husband says, look, I'm a big market guy. I know what this cash is worth. You should buy this and this piece of land, or this and this amount of land. She says, no. I want to buy what I want to buy. This and this piece of land, or whatever it is. We always go for whatever will produce more and cost less expenses. Whether it aligns with her will or with his. We have to do what's best for the marriage. What's going to bring in the most money and cost the least expenses. Also, we only buy things which will replenish themselves. Otherwise, the entire property will be used. You lose the principle, and you have no point anymore of this enactment. A woman brings into the marriage any of the following three things. A goat for the milk, a sheep for the shearings, or a palm tree for the fruit. So she never hands off the actual goat or the actual sheep or whatever. She gives them for the purpose of using the products. Even if he only owns the fruit, the products, he can keep on using them even if it destroys the principle. Because the milk is his. So keep on milking until you get all the milk you want. Or the fruits, whatever it is. If she brings in household items as user-fruct property, which the husband can use. He can use them. And he can wear them 100 times. He can use them as beds 100 times till it's all destroyed. Doesn't matter. It's his rights to use the fruit. He can use it whatever way he wants. And even if he divorces, whatever worn out leftover of these articles are remaining, no need to compensate. Just give them back as they are. Lamed Hey, Hoiru Hagoinim, the Goinim have taught that if it's the guaranteed property, even though all losses accrue to the husband, if they're still there and they perform somewhat of what their original purpose was for, you should be a nice guy and give them back to the woman as they are. So she brought you in, a nice set of china as the nichsei tzoyin barzel. You made use of them. You served 100 meals. Now they're all down in quality, but they're still there. Give it back to her as you divorce her. But if they couldn't even perform a resemblance of their work, say she brought you a jug, and you filled it up 100 times till it cracked, till it got melted, and now the pieces of clay don't do anything anymore. They're treated like they're stolen or lost. And all you have to do is replace the value that was at the marriage. No need to give her the actual articles. This has become a widespread custom. Anybody who gets married now goes in with the understanding that this is the responsibility that he has. Whatever property she brings in, if they're still there and performing somewhat of their work, they're going to go back to her as they are. But now, because of this, the same way, he doesn't have to replace the loss if he gives her back the actual objects. According to this custom, if the property goes up in value and it's still there, you must give it back to her as is without the profits. Final halacha. If a wife brings in slaves or maidservants to the marriage, the husband can force them to serve him in the home of a different wife. He has a second wife, he can take the first wife's slaves and have them serve him in his other house. Whether they're user-fruct or actual guaranteed slaves, doesn't matter. But you cannot take him to a different city. Different home is okay. Different city without your wife's consent, you cannot move your wife's slaves around.